So we're going to go ahead and get started. Before we dive in, a couple of reminders. Please keep your microphones and cameras off. We are recording this session, and anything you say and your camera will appear in that recording. So we do ask that you keep those off so we can get the cleanest recording possible. If you have questions, please enter them into the chat and we'll make sure our presenters see those. And with that, I will go ahead and turn it over to Professor David Schultz to kick us off.
Great, thank you very much. Let me just share my screen with everybody and get it all set up. I think we are ready. Yep, here we go. Perfect, good. So thank you very much. This is our overview of the 2020 Supreme Court term that just ended. So what we want to do today, Marshall and I, is to kind of do an overview, a little bit of some of the trends and things we should be thinking about at what happened from the past year. And of course, what we're going to also do is do some analysis in terms of maybe a little bit of crystal balling or predictions or thoughts in terms of thinking about what's going to happen with the term that started yesterday. Because as you all know or should know, is that the first Monday in October is the start of the new Supreme Court term. And as Marshall will point out, this is going to be a very, very packed and potentially contentious term coming up. And so we're going to look at that. Now, I should also mention the fact that, I wear dual hats in the world, as you see on my screen here. I'm a professor of political science at Hamline University, but I'm also a University of Minnesota law professor. And so part of my talk today weaves somewhere in terms of talking about the law aspect of what happens, understanding cases, doctrine, and so forth. But I also have to occasionally put on my political science hat and talk a little bit about what all this means from, let's say, the bigger picture of the relationship between law and politics in the United States. And so let us proceed. And when I start off, we have to obviously start off with some sort of observations and sort of highlights in terms of setting the context for the year. And remember, this was the term that saw the exit of Ruth Bader Ginsburg and the entering of Amy Coney Barrett. And it almost seems like an eternity ago, unfortunately, that Justice Ginsburg passed away not too far before the 2020 election and was replaced by Justice Barrett. So we want to think a little bit about the fact that, of course, this is a term where we saw a change in court personnel, and what does it mean? With that, the court moves perhaps further to the right with a 6-3 majority. I'm going to revisit that issue later on because, of course, as a law professor, I would say to you that the justices are apolitical. They what? As Chief Justice Roberts once said, his job is not to pitch and bat. His job is just to call balls and strikes. But of course, many of us wonder whether or not that's completely accurate, and sometimes peer beyond the robes and look at perhaps who appointed the justices and a little bit of what the ideology in terms of how it plays out. I'm going to give you some surprises today. One of them is going to be, surprisingly, that Justice Kavanaugh may be the new center of the court. And many of you are saying, whoa, what do you mean by that? Yeah, he may have replaced Chief Justice Roberts as the ideological center, or perhaps just as, let us say, the swing center of the court. Of course, we'll assess Justice Barrett's impact on the court. But then if I'm just thinking in general about who are some of the possible winners or issues that were winners this year, free speech wins. In fact, some people have said that the Supreme Court under Justice Roberts has perhaps been the most pro-First Amendment free speech court we have ever seen in American history. And perhaps that is true, and perhaps that's good. But I think some people might question that and say that maybe it's not always about free speech, but other things ought to be considered too. Free exercise of religion wins. It's also, again, a court very supportive of free exercise claims. And then we can say that what student athletes and expletive cheerleaders win, and Marshall's going to certainly give us more detail of both of those. And then criminal defendants, human rights, and labor in terms of collective bargaining or labor unions lose. And so we're going to see some clear patterns that emerge from this past year on the court and whether it perhaps signals something for the future. Now, one of the things that I, again, always remain interested in, and I always call it nice work if you can get it, for those of you who know the reference to a wonderful, wonderful American standard song here, is understanding how many cases the Supreme Court takes. And I remember back in the Stone Age, back when I was an undergraduate and then in law school, we were talking about what? There being about 4,000 requests for cert approximately every year for the Supreme Court. And by the time it actually took the cases and issued opinions on merits, we were looking at 200 to 300 opinions per year being issued on merits. And we always complained back then and said, my gosh, 4,000 cert petitions, it barely takes any. What's going on? The court's not working hard. But now look for the last couple of terms. Maybe 2019 we can explain in terms it was a pandemic year, a little bit of an unusual of a year. We had 61 merit opinions, 53 opinions after orals, 2 per curiam, 5 summary reversals. That's pretty low. But look at 220, 67 merit opinions released, 55 after orals, 2 per curiam, 8 summary reversals. We're seeing a longer term trend in which over time, the court is accepting fewer and fewer cases and issuing fewer and fewer opinions. And there are possibly 2 explanations for that. One of them is that it used to be in the 70s, each of the justices had their own clerks that were rifling through cert petitions and therefore would that helped up the numbers because each of the 9 justices were trying to select the cases they wanted. Now we have essentially the entire court using one cert pool. And so maybe that winnows it out even more in terms of what we're looking for in terms of possible number of opinions, being addressed. And then there are some people, and maybe Marshall and I might talk about this later, some people are arguing that there's a different docket on the Supreme Court now, and it's called the shadow docket, where the court is issuing lots of unwritten or one-line opinions as opposed to issuing opinions based upon the merits after orals. And there's a lot of fights going on about this alleged shadow docket, and that may be possible too. But anyhow, the point is that now with there being between 6,000 to 7,000 cert petitions per year, some years a little bit higher than that, your odds of getting a case up to the Supremes are reasonably low at this point, even lower than they were obviously 25 or 30 years ago. So counting on getting up to the Supremes, you need to have a lot going for your case in terms of being able to move it. Now, in terms of case composition, 97% were cert cases, 3% original jurisdiction. I'm always fascinated by the original jurisdiction cases, and I think I'll talk about them at the end, because they usually involve fights between states over water rights. And increasingly, as we're going through climate changes, and as we saw this past summer with droughts across the country, including in Minnesota, I wouldn't be surprised if we see more states fighting over water rights and maybe an exploding original jurisdiction docket. Someday, I think I should do a CLE just on original jurisdiction cases. For the 3 of us who find that interesting, it would be a fun CLE. And then the location where the cases are coming from, 6% from state courts, 1 from district court, 1 from military court, 9 cases or 13.4% criminal cases. And then look at it this way, about 33% are constitutional law cases. So an interesting mix here. This is the chart that I always find fascinating every year. It's from where the cases are coming, how many were affirmed, how many were reversed. And you take a look through this here, and it's listed by circuit, first, second, third, et cetera, et cetera. For our purposes, the 8th Circuit is where we're located. And notice that there was 1 case affirmed, 3 reversed, 75% reversal rate. There was a period about a half a dozen years ago, 2 or 3 years in a row, where from the 8th Circuit, 100% of the cases were reversed. Not a good track record. Winning at the 8th Circuit down in St. Louis did not bode well for you if the case went up to the Supremes. I think shifting alignments, who's on the Supreme Court, appointments by Obama, then Trump, and now Trump, and Biden, I think have changed things a little bit. But notice a couple interesting things here. The Ninth Circuit, which is California, Washington, Oregon, which is considered the most liberal circuit in the United States. Not only the sheer number of cases taken, 16, but how many were reversed, 15. This is a clash between what, let's say, an ideology or a set of justices viewing things at one level at the Supreme Court and lower courts viewing things another way. Now, the political scientist in me would say, of course, this is about ideology. The law professor in me would say, well, it's the Supreme Court exercising its discretionary authority to correct mistakes in the courts below. But then just also look at overall what? 82% of the cases accepted, of all the cases accepted, 82% are reversals. Good chance if your case gets accepted, the lower court is going to be overturned. Observation on case disposition. Like I said, if the court accepts the cases, odds you face a reversal. The Ninth Circuit, the most liberal court, the numerical loser. Again, the clash of conservative Supreme Court and more liberal lower courts. What does this mean for Biden appointees? As of July 13th, 2021, only 7 Biden judges confirmed by the Senate, with approximately 78 vacancies. It's been upped a little bit since then, but we're still not seeing a massive influx of new Biden appointees on the court, despite the fact that there were quite a few vacancies left when Donald Trump exited on January 20th this year. But again, it's something worth thinking about down the line here. Article 3 standing, I also want to throw in here in terms of observation. 5 cases this year addressed Article 3 standing and denied to limit it. This continues the Roberts Court trend of limits on access to federal courts by tightening up on standing, class actions, tougher requirements regarding showing injury or case in controversy, suggesting, depending on what your disposition is or what your case is, that maybe the state courts and state litigation are a better option for you for where you want to go in terms of maybe getting justice. Okay, years and years ago, I did a piece in which I looked at which justices were the fastest and slowest in turning around an opinion. And at the time I did it, by turning around an opinion, from day of oral arguments to issuing the opinion. And back when I did this piece in the 90s, Justice Ginsburg was by far the fastest judges, 42 days to turn around opinion. The second fastest was Sandra Day O'Connor. I did kind of a throwaway piece that talked about what I think it was called Justice Delayed, Justice Denied, the fastest justice in the East. It had all these campy gunfighter, gunslinger, language in there. But it was just kind of interesting to see who was fastest and slowest. And by the way, I sent that article when it was published to Justice Ginsburg, and she wrote me back, and I have a plaque made out of that where she said, "Thanks for the letter, because she said my grandchildren and my daughter think I'm the slowest eater around. I now have something to basically show over them." So it's just a fun piece. But here, just for the curiosity, Justice Thomas, 78 days to turn around an opinion. At one time, he was the slowest by far. The slowest now, Kagan, 132 days. At one time, the liberals were the fastest, the conservatives the slowest. Maybe this has something to do with changing ideological composition and dissents that factor into the rapidity of the opinion. The 2020, this is looking at who agrees with whom. What I'm interested in is in what percentage of the time justices vote with one another. And so, for example, Justice Roberts and Justice Thomas votes up together 75% of the time. Or somebody like, let's say, Kavanaugh and Barrett, 91% of the time. But I want you to look at an interesting statistic here. Roberts and Kavanaugh, 94% of the time. That's a pretty high level of agreement. It's like when Scalia and Thomas used to be about 94% voting together at the same time. But it just becomes interesting to look at how different justices align with others and how they might vote as blocks. Okay, so among justices for all cases voting alignments, Robert Kavanaugh, 94%, Breyer Kagan, 93%, Breyer Sotomayor, 93%, Barrett Gorsuch, 91%. Then the lowest agreements, Sotomayor, Alito 53, Sotomayor Thomas 55, Kagan Alito 58, and Sotomayor Barrett 58. Clearly, we're seeing patterns here that are starting to emerge. And again, this is for divided cases. The previous ones were all cases, but just in divided cases, which just where it was not doesn't include unanimous opinions. Again, we have similar patterns, but look at the lowest agreement: Sotomayor and Thomas, 13%. Just fascinating to look at how they divide up. Then, if we look at 5-4 opinions, how many 5-4 opinions there are? What percentage are they? And then who wins? Like if it breaks down ideologically, by ideological, we're measuring what president appointed him, a Democratic or Republican. In the 2020 term, there were 8 5-4 opinions, which were 12%, kind of low. Conservatives won about half of them on 5-4, liberals 37%. The historic average now over a 16-year period is 15 5-4 opinions per year, about 20%. Again, ideological conservative victory, 45%. We've seen increasingly a higher percentage over time of the conservatives winning split decisions. Opinion writing, who's doing lots of work here? Look at it again in terms of majority, concurrence, and dissent. Justice Roberts did a pretty good job, I think, in sparsing out majority opinion writing. Barrett, remember, joined the court late, so it's not a surprise that she would write fewer majority opinions, because I think she missed the first few weeks of orals and so forth. But just an interesting pattern here in terms of writing opinions. Again, majority. Notice Clarence Thomas is becoming the great concurrencer, I guess, that agrees, but for separate reasons on so many things. Majority rules, percentage in the majority. Again, I find this interesting here. Roberts has been in the majority in all cases, 91%. In split cases, 84%. I didn't do 5-4s here, but look down to somebody like Kavanaugh. He is in the majority in all cases, 97% of the time, and in split cases, 95% of the time. Pretty significant. Again, is he the new ideological center for the court? He's at 90% plus in the majority for all types of decisions. 87% majority in 5-4s, tied for the most majority opinions at 7, wrote 2 of the 5-4 opinions, tied for first. Now, he certainly doesn't get us up to the level of what we saw with Justice Kennedy when he was on the court. There was one presentation that Marshall and I did, I can't remember how many years ago, where Kennedy, where there were 24, I believe it was 24 5-4 opinions, and he was in the majority in all 24 of the 5-4 opinions. That's pretty good weight on the court. Okay, the Barrett factor. Barrett strengthens the conservative majority and pushes Roberts out of the swing role. Again, perhaps over to Kavanaugh. Depending on how people view the court now, it's either a 6-3 or a 5-4 conservative court. 6-3, if you simply look at Republican appointed versus Democratic appointed justices. Some people are saying that it's 5-4, that Justice Roberts, concerned about the institutional integrity of the court, seems to be operating in the last few years as more of a swing justice than anything else, perhaps. The emerged conservative majority, again, ideological 6-3 split, most common vote in split decisions. Barrett is the difference, again, shifts Roberts from 4-1-4 majority maker to less of a power player. Conservative outcomes, at least 50% in split cases, and unanimous decisions shift the overall court further to the right. Is this a partisanly viewed court with declining approval ratings? We've seen polls coming out in the last few weeks indicating, as the term is starting, that the approval rating and trust in the Supreme Court is at an all-time low. We're looking at around less than 40% for some of the polls. And three of the justices have had to, in the last few weeks, speak about this. So Justice Barrett recently at Notre Dame said, my goal here is to convince you that the court is not comprised of a bunch of partisan hacks. Justice Thomas says, I think the media makes it sound as though you are always going to going right to your personal preferences. So they think if you are anti-abortion or something personally, think it's how you're always going to come out. They think that you're for this or for that. They think you become a politician. And then Justice Breyer having to say Supreme Court justices aren't junior league politicians. All of them seem to be worried about the perception that the court is just what? Justices are just politicians with robes. Excuse me, I'm sorry. Makes me think of the great Macbeth line. I have it here. I have to do my Shakespeare for the day. The lady doth protest too much, methinks. I let you folks think about that. There's increased liberal pressure on Breyer to resign. Liberals want Breyer to resign now to give Biden a chance to replace him and avoid a Ginsburg issue. At age 82, he's the oldest court justice, and he's indicated in interviews he's feeling the pressure to resign at this point. So I'm going to stop there. I'll get to sort of the top decisions in a little while and turn it over to Marshall. And let me stop my screen share. Good.
Hello. Thank you very much, David. Always very interesting, your cybermetrics view of the court, kind of analytics for lawyers and judges for that matter too. Thank you very much. Pleasure to be here looking at the 2020-21 term. Just a couple comments to segue from David's remarks, Professor Schultz's remarks. That was when Kennedy was 24 for 24. I think that was 2011. So I don't know if they have celebrations about this. Although I read yesterday that Kennedy attended the Supreme Court opening ceremonies yesterday. Justice Kennedy was there, maybe in honor of his 10th year anniversary of his perfect record of 24 for 24 in the 5-4 split cases in the 2011 term. David's remarked about the 3 justices who recently have spoken out about views, public approval issues, and the concerns about them being viewed as partisan politicians. You can add a 4th to that too, because Justice Alito joined the other 3 just a couple of days ago. I think it was last Friday. Justice Alito spoke out at I think it was at the university law school proceeding, and he echoed the remarks of Thomas and Breyer and Justice Barrett about the concerns that people have about the court being too political or too partisan. So that makes 4 out of 9 have spoken out within the last few weeks on that issue. Speaking of speaking out, it was interesting too that Justice Sotomayor the other day, just last week, spoke out as well in an interview. She said that she used the phrase that people who are concerned about various civil liberties and civil rights issues are going to, quote, expect a lot of disappointment, unquote, during the upcoming term. And that sent some shudders down people's anatomies as well, as if she's kind of telling people to brace yourself on some of these high profile, marquee type, social issue type cases. The head count doesn't look good for the liberal wing on those cases. But let's take a look at what happened last term. And I put together my thoughts on the next couple pages. Next page, please, on 5 of the cases that I considered particularly interesting and informative, interesting and provocative. These aren't necessarily the high point cases, but most of them are. But these 5 caught my attention, and I think have some significant impact on where we're going as a society and and from a legal standpoint as well. So let's go to the first one, which was probably the marquee case. In a sense, it probably got the most attention. It was the college athletes can get paid case. NCAA versus Alston. Alston was a former college athlete. That's not for you old-time baseball fans. Walter Alston. That's not Walter Alston, the old manager of the Brooklyn and Los Angeles Dodgers. Different Alston. But it's an antitrust lawsuit brought by current and former college athletes against the NCAA. The NCAA, as you know, is the organization that regulates big-time college athletics and small-time college athletics too, for that matter. But they're the governing body for the college sports in this country. And under their rules, which were adopted by all of their member schools, athletes cannot get paid for outside of what are called educational related benefits, room, board, tuition. They get some small stipends in some sports, but it's very limited. They can't do commercial endorsements. They can't be paid by outside entities and businesses like professional athletes can be. And that rule has been enforced forever. But it was challenged by a number of athletes. At the same time that challenge was going on, California, the state of California, passed a statute that essentially allows college athletes in that state to be, enables them to be paid for commercial endorsements and the like. So the California statute, which governs that state, largest state in the country, kind of helped jumpstart this litigation. The litigation finally reached the Supreme Court, and after the lower court and the Ninth Circuit, sometimes the bête noire of the Supreme Court, both found that the NCAA regulations constituted a violation of the Sherman Act. It was a monopolistic conspiracy violating the antitrust laws. The Supreme Court affirmed in a 9-0 unanimous decision written by Justice Gorsuch. The court ruled that the limitations on athletes receiving outside compensation, so-called non-educational related benefits, it constitutes an antitrust violation because it's overly restrictive, and there are less restrictive alternatives that the NCAA could use to limit some of the concerns about athletes being paid for their services at the college level. The decision that caught the most attention and may have the most precedential impact, it already is having some impact, is the concurrence by Justice Kavanaugh. Justice Kavanaugh referenced the arrangement by limiting the outside pay that college athletes could receive as, he said, this is a form of price fixing. And price fixing of labor is ordinarily a textbook antitrust problem. Notice the phrase price fixing labor. He went on to say that the rule prescribes athletes from being able to, quote, obtain fair compensation for their work. So Justice Kavanaugh was focusing on the labor law issue here rather than the antitrust issue. And he used the phrase labor and work on several occasions in his concurrence. And the implication from his concurrence is that college athletes are employees. They do work. They're workers. They provide labor. And if reading Kavanaugh's concurrence, one would have thought it was written by Karl Marx. Has a very Marxian tone to it, but it also has been taken as a significant implication for organizing college athletes into unions. The takeaways from this case, first of all, is college athletes are going to be receiving compensation. They already are, as we know, including here in Minnesota. Gabe Stevenson, the college wrestler, University of Minnesota college wrestler, an Olympic gold medal winner, has already signed with the WWE, the professional wrestling organization. Other college athletes in Minnesota have signed or are about to sign endorsement promotion deals. One of the biggest that's going to go out, it hasn't gone out yet, but it's going to be the Paige Buchers, the Hopkins woman basketball player who plays for the University of Connecticut. She was college woman player of the year last year as a freshman, and she is believed to probably be sitting on a gold mine there, in large part because I think some of the more attractive college athletes for promotional endorsement purposes are going to be the big name ones in the football and basketball. More so basketball than football, probably, because there's fewer basketball players and they're visible and you can see who they are. And particularly for women as well, it's going to be a tremendous opportunity for star women athletes, not just in basketball, gymnastics too. Suni Lee here from Minnesota, to make significant amounts of money from what are called NIL rights, name, image, likeness. And we're already seeing this. But a second implication of this case is the one I referred to rising out of Justice Kavanaugh's concurrence, which is it opens the door, or reopens the door, for possibility of forming unions for college athletes of great significance, particularly in the big name sports, football, basketball, maybe hockey, not in the minor sports so much, but in the big name sports. As you may recall, back in 2015, the Northwestern University football team organized a union. The NLRB in Chicago, the Chicago regional branch, upheld the union for the Northwestern football team. The NLRB and headquarters in Washington, D.C. overruled that, and the headlines at that point said NLRB rules college athletes can't join unions. Well, that was true for that period of time, but just last week, the Biden administration's NLRB took a whole new tack on it, and the general counsel for the NLRB announced that they were reverting, or not reverting, but recanting that previous decision and saying that college athletes are eligible to form unions. We'll see where that goes now, but the implication of the Alston decision, not the implication, the Alston decision here thrust that issue into the forefront, and the NLRB now supports the notion of college athletes forming unions. A long haul before that comes into play, organizing the unions and organizing the athletes and forming unions and deciding which unions will be applicable to which sports and the like is going to be a long process. But over the next decade, I think we're going to see that play out in large part because of the Alston case. The next case is also a school education related case, and that's the finger case. And we'll go to the next slide. Manny Area School District versus BL. This case, I read, got the most hits on the internet, social media, internet searches from social media adherents reading about this case or writing about this case. It's the finger case. It's a cheerleader who was an aspirant for a cheerleading position at a public high school in Pennsylvania. Did not make the varsity team. Over the weekend, on her own social media laptop, this is not on school time and not on school equipment, she went on a rant. She posted a profanity-laced diatribe against the school and against the teachers who voted her off the cheerleading team and against the team itself, against the cheerleading team itself. And she capped it off by giving the proverbial finger on screen and in the Facebook account to the school and its authorities. She ended up getting suspended for a year from the intramural cheerleading team, the junior varsity team. So she was suspended from any participation on the cheerleading squad as a result of that. That case reached the Supreme Court. It was a First Amendment case. The ACLU took her case. Again, both lower courts ruled in favor of the student on First Amendment grounds, and the Supreme Court took it up. The issues posed in that case were a clash between the First Amendment right of the students to engage in free expression, and all the courts that heard the case and all the justices who were involved in the case at lower and Supreme Court level all agreed that the student was engaged in protected speech. There was no question that the student was engaged in protected First Amendment speech, notwithstanding her profanity. And there's a slew of case law which holds that profanity like that and giving the finger like that is constitutionally protected. In fact, there was an Eighth Circuit case decided earlier this year that in which a Minnesota case in which a person stopped for a traffic stop, gave the finger to the officer. You're a stopping officer here in Golden Valley, New Hope, Minnesota. That case reached the Eighth Circuit, and the court held that he was impermissibly given a traffic ticket and charged with disorderly conduct for giving a finger to an officer. So it's fairly well established that the finger is constitutionally protected. The issue in this case was whether the rights of school authorities to engage in student discipline overrides the First Amendment right of freedom of expression, even for obnoxious expression like that. And it was a revisiting of the doctrine that emerged, of course, from the Tinker versus Des Moines Independent School case back in the 1960s, late 1969 case. That was the famous Vietnam armband protest case in which the Supreme Court upheld the rights of students to wear protest armbands at school with the famous phrase, "The Constitution does not stop at the door, the schoolhouse door." So that was the first case that really recognized student rights of any significance back in the 60s. And this case was a reiteration of that principle. The court held here in an 8-1 decision written by Justice Breyer that the school's interest in avoiding disruption and unpleasantness does not outweigh the First Amendment rights of students engaged in off-campus, non-school hours. And as the decision says, it is necessary to protect the superfluous in order to protect the necessary. The language that we see from various times when the court upholds odious first speech, nevertheless, is constitutionally protected. And both Alito and Gorsuch did concur. They said this lies at the heart of the First Amendment protection. Thomas did dissent. Thomas accepted the school discipline argument that school discipline outweighs student right to engage in this kind of conduct. The issues and the takeaway from this case, I think, is first of all broader rights for student expression. Second, but it's important to note that the court specifically, and Breyer's decision specifically, noted that this was off-campus, non-school hours, and not using school equipment, school laptops. And that may make a difference in subsequent cases, but it basically gives leeway to students to say just about anything they want about their school, as long as they're doing it off-campus and not using school equipment. So that's one aspect of the case. It's also a reflection of what David mentioned earlier, that the First Amendment seems to be a sure winner with the current composition of the court. In fact, that goes back to Justice Roberts' original 15 years since his appointment. Roberts has proclaimed himself as being the strongest First Amendment advocate on the court, and the decisions going back during his era here, the Roberts court, have almost universally accepted First Amendment arguments, although, as David says, sometimes those aren't classic First Amendment, conventional First Amendment arguments. They have sometimes a political tone to them, but nonetheless, Roberts, this court is almost always genuflecting to First Amendment arguments, and this is an example of that. Secondly, I think this case has some implications for employment law. The many cases that we're seeing and reading about where public sector employees are disciplined for going on the internet and social media and making statements that are antisocial, racist statements, statements that are deemed to be unfavorable to the reputations of their organizations. It's oftentimes law enforcement people or other government employees, and they're being disciplined, oftentimes suspended or fired for making off-duty remarks that are constitutionally protected, nonetheless odious. This case, I think, is going to be applied, can be argued and applied in those contexts when government public sector employees are disciplined for off-duty engagement in not just internet activities, but any kind of activities, participating in white supremacist rallies, participating in other activities that are off-duty and unrelated to work and are constitutionally protected, even though obnoxious and odious. And I think we're going to see this case, the Maney area school case, cited for those advocating for the rights of employees in those contexts. I know it's going to be cited in some of those cases because I've already done it a couple of times. So I think we're going to see this case, the school finger case, become an important feature in employment law, off-duty employment law cases. The next slide is a religious case, and this, again, David mentioned this, and I'll concur that another way, almost a surefire way to win a case before the Supreme Court in recent days, recent years, I should say, is raising the free exercise claim under the First Amendment. A free exercise claim almost always gets the sympathy of the Roberts Court. It did in the two cases I'm going to talk about now. One of them is the first COVID case that the courts had. Courts only really had three COVID-related cases. This was the first one. This was a year ago, and this was a case that reached the Supreme Court as in review of a gubernatorial lockdown. We all remember that a year ago, back in the height of COVID, the lockdowns, the shutdowns, the gubernatorial directives requiring businesses to close down or at least limit capacity, which we saw here in Minnesota and many states, New York, California, and many of the larger states. And as I said, Minnesota we had our own lockdowns and shutdowns here as well. The case that reached the Supreme Court was a religious case. It concerned the lockdown, shutdown order directives of in New York of Governor Cuomo, or I should say former Governor Cuomo, then Governor Cuomo, whose directives during the COVID lockdown period had limitations on the size of religious assemblies. They didn't preclude or shut down religious assemblies, but they had significant limitations on the number of people who could assemble for worship because of COVID. These were COVID pandemic restrictions. The challenge was brought by the Brooklyn Catholic Diocese and 2 Orthodox Jewish synagogues in New York challenging them. There were similar challenges brought in other states, including California, but the New York case reached the Supreme Court first, and the lower court had upheld the restrictions, and the case then reached the Supreme Court, and the issue was whether these restrictions on the number or the gathering of people at religious worship assemblies could or could not be enforced. And the Supreme Court, in a 5-4 per curiam rule held that the restrictions violated the First Amendment free exercise clause. So the court enjoined and essentially invalidated the New York lockdown restrictions as they apply to religious institutions. The court's rationale in the per curiam decision was that the restrictions violate the minimum requirement of neutrality toward religion because they single out houses of worship for particularly harsh treatment. And the court pointed to the fact that there were other limitations, of course, in effect during these lockdowns and shutdowns, but retail facilities, other places of business did not have the same kind of limitations as that were imposed on religious entities. Now, the argument made by the Cuomo administration and others who supported the lockdown limitations was that religious worship is different than walking through a mall or a shopping center or a retail establishment because people are in close contact, they're sitting literally right next to each other, and they're vocalizing. So the risks are greater, the argument was made, in religious worship than they are in walking through a shopping center or going to a Walmart. But nevertheless, the court said these single out houses of worship, and that's a big issue in these free exercise cases, the targeting or singling out. To the extent that claimants can show that their religious exercise has been somehow treated differently than other activities, they're going to have a very good chance of winning before the Supreme Court. The dissent pointed out to the need for these kind of restrictions because of the pandemic, and asking for discretion to be given to government officials in engaging in medical and scientific matters. But the majority of the court said, don't confuse us with the science here. We don't care about the science. All we care about is the religious aspect of this, and the First Amendment prevailed. Takeaways: limitation of emergency powers. It's a little bit outdated in that sense because the emergency powers are being used less frequently now, although they still exist in some places. But there may be the post-pandemic implications here is a strong vocalization of the free exercise claim, and an example of how it can override other significant public policy concerns. Another case on the next slide where free exercise won again is Fulton versus City of Philadelphia. In this case, involved the Philadelphia a ruling by the City of Philadelphia Civil Rights Commission, Human Rights Commission, similar to the Minneapolis Civil Rights Commission. State of Minnesota has a Minnesota Human Rights Department. But this is the local agency in Philadelphia that oversees human rights, civil rights type claims at the local level. A gay couple, 2 men, wanted to serve as foster parents for children from a Catholic social service agency. The gay couple applied for permission to foster children that were overseen by and administered by the Catholic Social Services Agency. The Catholic agency's rules prohibited the foster parenting of unmarried gay couple. Even for that matter, a married gay couple, it didn't matter. If they're gay, they don't get to foster Catholic children, according to this agency. The Philadelphia Civil Rights Organization said that violates our civil rights ordinance and ruled and said they have to allow fostering of children by gays. That reached the Supreme Court, and it was reversed. It was reversed 9-0, a unanimous ruling with Chief Justice Roberts writing the opinion. his opinion for the unanimous court, all the liberals joined, is that the refusal by the city to recognize the Catholic Social Services Agency's free exercise claim is invalid because it burdens the agency by forcing it to choose between curtailing its mission or acting inconsistent with its beliefs. The mission of the church, the mission of the social services agency was to adhere to Catholic doctrine. Catholic doctrine precluded fostering or adopting, for that matter, adoptions by gay couples. Therefore, the court ruled that adherence to the Catholic Church mission overrode the civil rights and anti-discrimination law in Philadelphia, and by implication, any anti-discrimination laws for that matter. There are a number of concurrences, and what's interesting about the concurrences is that Gorsuch, joined by Alito, really hammered Roberts' decision and said it's far too narrow. Roberts' decision was a very narrow decision based upon the particular facts of this case and the mission of this church. What Gorsuch advocated was overturning the long-standing employment decision versus Smith doctrine, goes back 30 years, in which the court said in that case, and that was a Scalia decision, that religious free exercise claims do not override neutral, generally applicable laws. And that's generally been the law since that case in 1990. There have been some changes statutorily with the Religious Freedom Act passed by Congress after that, but generally speaking, one cannot avoid compliance with the law by claiming that they have a sincere religious belief that exempts them from complying with the law. Gorsuch and Alito said we should take this opportunity to overturn that doctrine entirely and give even more potency to freedom of exercise claims, or put another way, they seem to suggest that the assertion of a sincere religious belief overcomes just about any law to the contrary. Well, we're seeing that arise now with the vaccination exemptions, in which religious exemptions are being claimed by a number of people against being vaccinated in the private sector and in the public sector as well. And the Biden mandates, which haven't gone into effect yet, are facing a number of challenges on religious grounds, and it's going to be a real battleground. It already is a battleground. The issue is, can people exempt out from vaccination mandates on religious grounds? The Fulton case doesn't go that far, but it recognizes the issue as a significant one. The Gorsuch-Alito concurrence would go farther and say, if you have a religious claim, you're exempt from compliance with just about any law. We'll see how far that goes, but that's a significant matter to watch in the next go round. The final case I will talk about, my fifth case, which is on the next slide, is not a major case. This one really went below radar, but it's interesting for a couple of reasons. One is it's interesting as a non-defamation case, and because I do a lot of defamation, I said, well, this is kind of it's a defamation case that's not called defamation. It also reflects the court's aversion to class actions, and David mentioned that this court for many, many years has not been friendly to class actions, and here's another example in which they essentially reject in most parts a class action. This was a mistaken credit report. One of the three large credit reporting agencies, TransUnion, there's two others, mistakenly reported that an applicant for credit was a match for a drug trafficker who was on the terrorist watch list. They were wrong. The person had the same name, but it wasn't the same person. So they made a mistake, and there was a number of mistakes they made with matching up people with names who were on the terrorist watch list, and they were denied credit because of it. That led to this lawsuit, which went through the California court system as a class action by 8,000 people. There were two basic subclasses. One subclass consisted of about 2,000 of the people, close to 2,000 of the people, about 1,800 of them, who actually had been denied credit. That was about 20% of the class had been denied credit. About 80% of the class hadn't been denied credit, but they had been spotted, but their records in the held by TransUnion, I mismatched them with on the terrorist watch list. So they hadn't suffered any harm yet, but their records were logged with this terrorist watch list mistake. They were not it was a mistaken identity. So the case reaches the Supreme Court, and it was a 5-4 decision. Justice Kavanaugh wrote the decision. The judgment below, which had been reduced to 40 million, was upheld for those 20% of the class members, about 1,800, who actually had suffered a loss of credit because it was reported that they were on the terrorist watch list. Although it was not a defamation case, the case was brought under the Fair Credit Reporting Act. The Kavanaugh's decision treated it like defamation. He said, this is like defamation, a false statement of fact that hurts someone's reputation. And that constitutes a violation of the Fair Credit Reporting Act for those individuals who actually had suffered a credit harm to their credit, lost a credit application. However, for the bulk of the class, the bulk of the $40 million was overturned because those class members lacked standing, since they suffered no concrete harm because their credit reports were not circulated to anyone. In other words, they had not been denied credit. The mistaken information was lodged internally in TransUnion's records, but they couldn't prove that it was disseminated to third parties. So the bulk of the class action claimants were denied relief in the case. Interestingly, there were the two dissenters were Thomas and Kagan. They don't match up too much on David's analytics, I don't think, but Thomas and Kagan both dissented. Thomas dissented because he thought it was an inequity to mistreat, quote, law-abiding citizens, unquote. He said these people didn't violate the laws, but they're being deemed as terrorists, and that's an inequity to law-abiding citizens and to consumers. He was he lamented the unfairness to consumers. Kagan dissented and said it wasn't speculative at all that injuries can occur because that's what credit companies do. They sell reports to third parties, and these people, once their reports are sold, they're going to have a significant impact on their credit rating. But that didn't prevail, and the class action was largely disbanded, not totally, but largely disbanded. Takeaways from the case: restrictions on class actions. We see them all the time. I don't know if I can recall in the Roberts era, and maybe David, when he comes back in, can help me out on this. I don't recall class action ever being upheld in the Roberts era, the last 15 years. This one is sort of upheld to a limited extent, but I don't remember class claimants walking down the steps of the Supreme Court building, walking over those microphones and touting that they won a Supreme Court decision. Maybe David will help me on that. And standing limitations, which is a big deal too. That's another thing. Free exercise gets a lot of attention at the court. As I said, for First Amendment claims and standing, raising the specter of standing is a very powerful defense before the Roberts Court. Let's take a quick look at what's coming up this term, and then I'll go back to David here in the remaining time. Let's go to the next slide. Just looking ahead here to 5 cases, there's a lot more on the docket. The court, I think, started the term yesterday with 22 cases on its docket, but they'll ultimately bulk that up to that magnificent number of about the high 60s. Here's a few of the high profile cases. The gun control case, Second Amendment case, that's a big one. This is a New York case. It concerns whether authorities can require proper cause for concealed carry firearm licenses. It really goes to the issue of what limitations, if any, can be placed upon concealed carry limitations. The argument by the NRA associated group is none. And the argument for the government in this case, the New York case, is that we have some authority to decide who gets a concealed carry or not. This is a big Second Amendment case. The abortion reproductive rights case, needless to say, is going to be the marquee case. Dobbs versus Jackson. That's not the Texas case. It's the Mississippi 15-week case. But the case has been postured by the Mississippi authorities as an all-out assault on Roe. They're asking for the court to disband Roe altogether. Although the court doesn't have to go that far, they could uphold the 15-week limitation without disowning Roe in its entirety. But nevertheless, Mississippi is asking the court to overrule and reverse the Roe rationale altogether. The court may find a middle ground and uphold this law because it's not a total restriction, it's a limitation of 15 weeks. The Texas one, as we know, is a 6-week one. Incidentally, there is another abortion case on the docket. It's coming up next week. It's a low-profile case. It's a Kentucky case in which the Kentucky Attorney General, a Republican, is trying to revive a lawsuit that deals with Kentucky's restrictive abortion requirements, which the governor there refused to abide by. And the case has already been moved. It's already gone through the legal system and has been dismissed. But the Attorney General in Kentucky is trying to revive this old abortion case to try to give it new life. That's going to be heard next week, next Tuesday. But that's a low-profile abortion case. The big one is the Dobbs, Mississippi case. A couple more. There's a billboard advertising case. It's not really significant, but I note it because it involves First Amendment, and the court likes to tinker with First Amendment. This is differential rules for billboards if they're on premises or off premises. Not a real attention grabber, except to the extent that it has some First Amendment implications that could lead to other determinations regarding differential treatment of First Amendment messages. Immigration removal case. There's a few immigration cases before the court, and a death penalty case. This is the Boston Marathon death penalty case. The surviving Boston Marathon bomber was sentenced to death, and the death sentence was reversed. His conviction wasn't reversed, but his sentence was the sentence was overturned because of pre-trial publicity. And the court is revisiting that issue of to what extent is pretrial publicity usable. It can be used to overturn criminal convictions, a matter that has some significance here. One of the 14 issues raised in appeal by Derek Chauvin, now pending before the Minnesota Court of Appeals, is prejudicial pretrial publicity. The Saranoff case is going to address that at the Supreme Court level. There's one other death penalty case. There's several other death penalty cases before the court this term. Another interesting one is the lay hands case. That they've taken a case to determine whether a death penalty, a person about to be executed in Texas, can have a minister or a cleric come into the death chamber and actually touch him during the proceeding, during the execution, as an exercise of his free exercise of religion. Interesting case, and again, it raises the extent and scope of the free exercise clause in a death penalty context. So those are some of the cases to watch for, among others. And it'll be an interesting term. And as David indicated at the outset, this is a term that may be the most contentious and perhaps most significant in many, many years because of these high-profile cases and others yet to be added. David, what do you think about that?
You come back in and share. A couple of things here. First, I'm just going to run through very briefly here my hold on a second here. My quick comments here. I'll just mention it quickly of some of the big cases. We obviously couldn't, of course, do a complete review of all the 60-some opinions. You hit on many of them here from before, and I'm going to address a couple of questions you posed here. I wanted to note the California versus Texas case, which people thought was going to be important, upholds the constitutionally Affordable Care Act, even though the tax for those who do not have insurance was eliminated. You talked about Fulton and Alston. I'll pass over that. Mahani, you also talked about here. For those of us who are election law people, Branovich versus DNC is also about election law rules in which the court upheld a state law banning third parties from picking up ballots. It limited the scope of the Voting Rights Act, Section 2, and said that basically judgments regarding voter dilution have to look at totality of circumstances. This is a big decision in election law, and part of the Democrats in Congress efforts to pass election law or voting rights legislation aims at this decision. Americans for Prosperity versus Bonta, a California law compelling disclosure for major donors to charities, violated the First Amendment. The court takes us all the way back to NAACP versus Alabama in the 1950s, where the state of Alabama tried to basically intimidate NAACP by requiring disclosure of officers and members. Then there's I think the Cedar Point nursery case is interesting, all about state regulation giving union organizers the right to visit farm workers on fields violated private property rights. Then there's kind of an interesting case about Cargill and Nestle cannot be sued in the U.S. for human rights violations in the Ivory Coast. This is a trimming back of long-arm jurisdiction that oftentimes the federal courts used to allow for. And then I just sort of throw in some top criminal decisions here. Jones versus Mississippi, state need not find juveniles permanently incorrigible to sentence them to, supposed to say life, not live, to life in prison, pardon me. Court, Edwards versus Vanoy, court decision establishing new procedural rules may never provide relief for inmates whose direct appeals have concluded. Basically, you can't go retroactive. And then Borden versus the U.S., I found an interesting case that a police officer who shoots at somebody, I correct myself, Borden, a reckless offense cannot qualify as a violent felony if it only requires mens rea of a recklessness, a less culpable standard. That's important in terms of our classification of how we think about felonies. These are a couple of other cases here. Shin versus Kayer, vacates and remands, Ninth Circuit opinion regarding post-conviction relief for an Arizona death row inmate, basically saying that the Anti-Terrorism Effective Death Penalty Act of 1996 places some limits on the ability to be able to seek relief for arguments about ineffective assistance of legal counsel. And this is a case I was going to start to reference. Torres versus Madrid. A Fourth Amendment seizure occurs when an officer shoots someone who temporarily eludes capture after the shooting. Essentially, the court normally says that issues of search and seizure, or rather issues of excessive use of force, are evaluated in terms of Fourth Amendment search and seizure claims. And here, even if the officer shoots, wounds you, but you elude escape, that still constitutes a Fourth Amendment seizure. Pandemic cases I'll pass over here. As Marshall pointed out, the court has been grappling with pandemic cases, and I suspect we're going to see some more of those occur. And maybe it might revisit some the old Jacobson case versus Massachusetts from the early 20th century that upheld state mandatory vaccines. We don't know. And then I mentioned to you the two original jurisdiction cases, a couple of states fighting over water and water rights. I suspect we're going to see more of those in the future. And then for admin law nerds like me, a case, United States versus Arthrex, unreviewable authority wielded by administrative patent judges during inter-party review is incompatible with their appointments by the Secretary of Commerce to an interior office. This is all about the structure of who gets to appoint whom and who gets to review decisions by administrative patent judges. So last thing I want to say is that, as Marshall had posed a point here, is that I cannot think of a single class action that the Roberts Court has upheld. In fact, I think if I remember correctly, it was the Dukes versus Walmart case, which stands out as a particularly notable decision that made it difficult for women to proceed in a class action against Walmart, and has had pretty significant reverberations across the map in terms of making it more difficult to mount class actions. So I think I finished my part. I don't know I know we're a little bit over here, but if anybody has any questions, if they would like to ask, I guess we could probably entertain a few.
There was one question in the chat. The question is, how can I explain to my non-lawyer friends how Supreme Court judges are at the same time totally objective, yet they tend to vote in ways that appears conservative or liberal?
That's a tough question here. That I struggle with this all the time and say that, well, on the one hand, I'm going to say that nobody comes to the bench totally without bias, comes to the bench without having thought about the law at some point. And I guess we're going to have to come to accept about a certain amount of bias within the system. And I don't really have a good answer on this one, is that I think judges can look at things in terms of saying they're not biased in the sense of perhaps particular parties. But we do unfortunately have increasing evidence that their ideological orientations do affect. And so I'm not sure I can give a good answer. And this is scary to me, because if the public ultimately loses faith in the way the judges are voting, and it looks like they are voting ideology, this is not good in terms of how the courts are viewed in our society. Marshall, do you want to take the one about potential appointments?
Yeah, I did a piece. I'll give a plug here to a publication. I did a piece in MinPost. If you want to look it up, you can find it. MinPost, that's the online newspaper that David writes for a lot more than I do, about packing the court. And I talked about why packing the court's a good idea for non-political, non-ideological reasons. And I focused on one of the things that David mentioned about the number of cases. If you get more judges on the court, setting aside the politics, which is hard to do, but because it's an overriding feature, but just from a judicial administration standpoint, it may be wise to have more judges. Maybe have them sitting in five member panels and have 15 judges. For just they'll hear more cases, and like more issues can be resolved apart from the politics of it. So you might want to take a look at that article I wrote for MinPost. It's about 2 years ago, but you can go online, hit MinPost, my name, and court packing, and it's a view of court packing without the politics. But I'll leave that. Those are my thoughts on it. But David, what are your thoughts?
At this point, I think there's been a lot of proposals for perhaps trying to change the way justices are appointed. Of course, all this is going to probably require, some kind of constitutional amendment to do these kind of things in terms of if you're going to move away from appointment to something else. But people have talked for years about saying, could we do amendments to maybe put term limits or time limits on justices and so forth? I mean, that's something that's being looked at this point. The Biden administration is looking at whether or not it wants to expand the size of the court. But all those are possibilities, but I'm not sure anything is going to really change at this point. And in terms of future justices, again, it looks most likely at this point that the pressure is on Breyer at this point in terms of trying to get him to step down in the next few months so that Biden can replace him with somebody. I just don't know.
Incidentally, one thing Biden did say during the campaign is that his first appointment will be a Black woman jurist, and he's committed to that. So if Breyer were to step down, or if there are any other vacancy, he's committed to appointing a Black woman jurist.
Interesting.
Another article, another matter I commented on from MinPost. If you go on the internet, hit MinPost, and the article is about Black women jurists to be appointed by Biden. It's a piece I wrote which comments on that and offers some suggestions of potential candidates. And the candidates are drawn here from our Minnesota judiciary, if you're interested in my thoughts on that topic.
Okay, we do have another question. Someone is wondering if there is enough time to talk about the shadow docket and the controversy surrounding decisions made that way.
Yeah, let me step in on that for a minute, because David mentioned I might talk about it, and I didn't, and I'll leave it to him because as the academic to talk about that. But that was the topic of Alito's speech the other day. I think it was last Thursday or Friday. He really railed into this notion in the media and other places that they have some secret shadow docket. He said, no, that's not true. We're not doing that. Yet, nonetheless, the numbers and statistics indicate that they are, as David said, handling a much larger number of cases, an infinitely number of larger cases, an infinitely larger number of cases in exactly that way. Right, David?
You're absolutely correct. And the fact that if we look at the cases that dealt with, for example, the pandemic, these were largely summary opinions. They were not argued orally. That's what we mean in part of the shadow docket, the Texas abortion case. And so this is what's increasingly, I think, concerned is the fact that cases are coming up. The court is being asked to sort of address, let us say, TROs or something like that. And it's using those as occasions to render essentially opinions in a lot of cases that is really starting to amount to, as we pointed out here, what's looking like a shadow docket, where the court is just issuing what one sentence, or oftentimes not even one sentence. It'll just say denied or affirmed or something like that and go. And so that's something that we need to be looking toward down the line here, is the increasing use of these type of, again, we're going to call them summary affirmances or denials, or decisions on TROs as effectively producing substantive decisions.
All right. Well, Sarah, do you have any more questions in your queue? I do not.
I do not either.
Okay. Well, thank you both so very much then. I think we can probably wrap things up unless you have a final word. Okay. Thanks everybody for attending. We will post a recording of today's presentation on our website after we have time to get through that process. So you can look for that. I also put links to the 2 articles that Marshall Tannick mentioned in the chat.
You may as well throw in a third as long as you're linking articles. I'll give a plug to another publication, but this week's edition, this week's edition of Minnesota Lawyer Magazine has a piece by me reviewing the upcoming term of the Supreme Court and focusing on the issue, one of the issues that David mentioned, which is the role of the swing judge, justice. In this case, I talked about Justice Roberts' central role in some of the big high-profile cases on this term's docket. However, David is absolutely right about the Kavanaugh factor, that it may be that Kavanaugh becomes even a more significant central figure in this year's docket, particularly in the high-profile Second Amendment and abortion cases.
Excellent. I will pull that up and post it. All right. Well, thank you everyone so much for attending. And thank you, speakers. That was wonderful.
Thank you.
Thank you.